Hello everyone. Today we are going to see the topic of vesting of legacies under the Indian Succession Act. The Indian Succession Act speaks about the situations when a legacy becomes a vested legacy to any beneficiary. It is with reference to testamentary succession as well as with reference to intestate succession, and therefore this concept is a very important concept for us to understand. So there are three ways or three steps in which we may say that interest is created in property. Interest, when we are saying talking about interest basically means a right which is created in the property. And when this interest which is there, it is with reference not only to just the possession of it, but the ownership per se of the right which is created in the property when we are talking about a property with especially under the Indian Succession Act. So there are three ways in which this interest can be seen or found out under the Indian Succession Act. The first is the contingent interest, the second one is vested interest, and the third one is absolute interest. So however, never said absolute interest per se in anywhere in the law, but it is easier for us to understand these three concepts if we, instead of just saying interest in the third part, we say it is an absolute interest. So, to understand these three concepts, I would like to speak about a few things which are given under the Indian Succession Act. The Indian Succession Act, Section 190, speaks about the date of vesting of legacy on payment or possession postponed. So, for understanding this concept of vesting of legacy, let us just first go through this section under the Indian Succession Act, where by the terms of the bequest, a legatee is not entitled to immediate possession of the thing bequeathed. A right to receive it at the proper time shall, unless a contrary intention appears by the will, become vested in the legatee on the testator's death, and shall pass to the legatee's representatives if he dies before that time and without having received the legacy, and in such cases the legacy is from the testator's death to be vested in interest. So, an explanation is given to this section. An intention that the legacy to any person shall not become vested in interest in him, uh, not to be inferred merely from any provision whereby the payment or possession of the thing bequeathed is postponed, or whereby the prior interest therein is bequeathed to some other person, or whereby the income arising from the fund bequest is directed to be accumulated until the time of payment arrives, or from a provision that if a particular event shall happen, the legacy shall go to another person. So we are talking about contingencies, we are talking about conditions in the explanation of this section. There are a few illustrations which have been given under this section. You can very well go through these illustrations. I have referred to the official site of indiacode.nic.in, which is the official website which provides all the legislations with reference to all the laws which are in force in India currently. So, we talk about these three interests step by step. One thing which we have to remember is that an interest to be complete and absolute, there are certain requirements which need to be complied with. For example, if we say that if X is going to bequeath his property to Y only when a specific uncertain event might take place. So there are two things over here, specific and uncertain. So the event which is the reason or the basis on which the interest is going to be transferred is a specific event. Say for example, if it rains after 3 days I will give away my property to you. Or let us say in this current scenario, if the COVID-19 virus will end by the end of May, the examinations will be conducted in the month of June or in the month of July. So this is something which is a contingency right now, and therefore if that specific but uncertain event will take place, then the interest which will be created will be a contingent interest on the happening of the event. The contingent interest will become an absolute interest. If, however, the event might not take place because there is uncertainty involved, this event will be a non-possible event, and therefore there will be no bequest after this event. The second example which I can tell you is, let us say I will give X property on attainment of majority. So X, who is, let us say, not an unborn person, but a person who is very much alive, but a minor, if at all a person bequests his property to this X, who is currently a minor, but obviously is going to become a major, because when a person is born, he is obviously going to grow and have birthdays every year and is going to be of that particular age at some point of time. Now there is only one possibility, that if at all the person before attaining majority, if this X before attaining majority is unable, or let us say he dies before attaining majority, it is only then that this vested interest will not be fructified into an absolute interest. In all other circumstances, the vested interest, because of the event which is being spoken about, the specific event which is being spoken about is certain. Or let us say I will give X property on 1st of January 2021. Now it is obviously, whoever stops it, come what may, 1st of January 2021 is going to be in existence at some specified certain time, and therefore the property will become vested the moment this kind of a condition, or let us say this kind of a prerequisite is put on the property. Okay, so a later event, this which we spoke about just now, that the date of vesting of legacy is postponed. This later event is something which is certain. It is definitely going to take place, and therefore the bequest will be a bequest of vested interest. We come to the next section, and that is on contingent specified uncertain event. Like I already discussed, we will just see the section. A legacy bequest in case of a specified uncertain event shall happen does not vest until that event actually happens. Subsection 2 of section 120 says, a legacy bequest in case of a specified uncertain event shall not happen, does not vest until the happening of the event becomes impossible. Thirdly, in either case, until the condition has been fulfilled, the interest of the legatee is contingent. So something, if at all there is a specified uncertain event which we are talking about, if the event is positive in nature, that such and such a thing should happen, then the bequest will become complete. Or if the event is negative, as in such and such a thing should not happen for the event to be a valid one. So in either of the ways, there has to be the happening of the event or impossibility of happening of the event. It is only then that the vesting becomes above the contingent level. So contingent interest will be like the step 1 towards the attainment of the property. Vesting of legacy becomes the step 2. Here, even if one says that vesting of legacy has taken place, the actual transfer has not yet taken place, because of which we have to realize that there is still a difference between the absolute interest and the vesting of interest. For example, when a person dies and his property by testamentary succession or even intestate succession is, the moment he dies, we know that there is this basic rule of property law that no property should have a dead owner, or rather conversely, every property should have a living owner. Now because of this fact, the moment a person dies, it is presumed that the heirs have already vested interest in the property, but firstly, prima facie, no one knows how much interest of how much property any person is having. Secondly, there might be a testament, and therefore, who knows what is written in the will. So, there is a possibility of change in the vesting nature. However, the vesting of interest definitely takes place the moment a person dies, and therefore, on completion of the whole process, let's just say for example, if there is a will, then a probate of the will has to be made, then it has to be executed, and then there has to be a changes which need to be incorporated in the property documents. It is only then that a person who has got a vested interest becomes the absolute owner of the property. Similarly, if at all it is an intestate succession, then there has to be a succession certificate of the property, and then the succession certificate has to be executed and written in the property documents, and it is only then that the property will be the new owners can be called as the owners. Till that time they are the vested interest holders of the property. So vesting is one step less than the ownership, the absolute ownership of property, and contingency is one step less with reference to the possibility and non-possibility of happening. I hope you have understood these three concepts. I will be elaborating further on these topics in the lectures to come. Thank you very much.